Welcome back to Real Estate School. Today we have a great video on voluntary and involuntary transfer of title. So let's get started. Voluntary and involuntary transfer of title. Ownership of real property is transferred from one person to another in many ways. Sometimes an owner voluntarily transfers title by deed or in a will. In other cases, title is transferred involuntarily, as in the case of a foreclosure sale. Alienation is the legal term that includes all the various methods of transfer, voluntary and involuntary. Voluntary alienation is the most common way to transfer ownership of real property. Voluntary alienation is an action that the property owner takes of his or her own free will. It may be accomplished through various methods. For example, sale of property, in which the owner agrees to hand over title in exchange for consideration, usually completed with a deed. Gift of a deed, for example, a father deeds part of the family farm to his child. Dedication of private property for public use. For example, a developer dedicates land for streets within a new subdivision, or a property owner dedicates land to a municipality for a park. Grant of title to property from the government to an individual. For example, historically, governments issued land grants to public companies to build railroads and to colleges and universities to establish campuses. Devise is the distribution of real property according to the instructions in a will. When somebody dies with a valid will in place, he is said to have died testate. Probate is the process that determines both the validity of the will and the distribution of the property. Remember, many topics discussed in this video fall within the practice of law. Any advice given to a buyer or a seller could be construed as legal advice, which is off limits to real estate licensees. Clients and customers should be advised to seek legal counsel. Involuntary alienation. Involuntary alienation is the transfer of title and an interest in real property against the will of the owner, or without action by the owner. State law regulates all forms of involuntary alienation, whether such transfer occurs by laws of descent, abandonment, foreclosure, eminent domain, adverse possession, or estoppel. Let's take these one at a time. First, laws of descent. When a person dies without a will, which is intestate, good term to know, property automatically descends to any natural heirs or next of kin as provided for by state law through the process of descent. Each state has some sort of law of descent and distribution that lists those persons in a close enough degree of kinship to be considered natural heirs. A court-appointed administrator will handle the affairs of the estate. The process may also be called intestate succession. In the absence of heirs, title transfers to the state or county by escheat, abandonment. Property that has been abandoned for a statutory period may also escheat to the state or county. Foreclosure. A property owner who fails to fulfill loan obligations or pay taxes may lose an estate through foreclosure. Adverse possession. An individual who makes a claim to certain property takes exclusive possession of it by excluding the true owner and any other title claimants, and, most important, uses it, may take title away from an owner who fails to use or inspect the property for a period of years. The law recognizes that the use of the land is an important function of its ownership. Adverse possession also known as title by prescription, is similar to an easement by prescription, but instead of acquiring an easement or an easement interest in the property, the actual title is acquired. They're both a way to gain access legally to someone else's land, but the extent of the use is different. A prescriptive easement occurs when a trespasser meets the criteria for open and notorious. They don't need to possess it, but they do need to use the property. An example of a prescriptive easement would be if children used a path through your property to reach school. If they have been doing this openly for years and you've noticed but never stopped them, they likely will be able to receive a prescriptive easement to continue using that piece of land in the same way. They won't gain title or ownership of the land, just the right to continue using it. An acronym for the elements required to gain ownership of a property by adverse possession is NACHO. That stands for notorious, adverse, continuous, hostile, and open. Let's briefly discuss each of these. First, notorious, or known by others. Meaning that if someone in the community was asked who owns the property, they would answer that the trespasser owned the property. However, the true owner doesn't need to be aware of the notorious possession for it to meet the legal requirements. Adverse, against the owner's true right of possession. Actual occupation of land with the intent to keep it solely for oneself. Continuous, or uninterrupted. The trespasser must maintain continuous possession of the property during the state's statutory period. If they leave the property before the statutory period is completed, they need to restart the statutory period before they can claim adverse possession. Hostile, without the true owner's consent. Property trespassing doesn't need to be malicious or unfriendly to qualify for adverse possession. But the trespassing needs to be done in a way that infringes on the owner's rights without permission. If the owner allowed the trespassing, there can't be an adverse possession claim, as it is not hostile. Open, or obvious to anyone who looks. It needs to be clear to anyone who looks that the trespasser is in possession of the property. No hiding in the shadows or keeping the occupation of the land a secret. It needs to be out there in the open for anyone who is paying attention to see. Adverse possession is most likely to come into play over a disputed property line and rarely results in the conveyance of title to large parcels. The necessary period of uninterrupted possession is a matter of state law. The statutory period ranges from as few as 5 years in some states to as many as 30 in others. A shorter time period may be accompanied by the requirement for the adverse possessor to make all property tax payments. To claim legal title, the adverse possessor normally files an action in court to receive undisputed title. In some states, an adverse possessor may tack on time from a previous adverse possessor so long as there is a privity between them, meaning some type of non-hostile relationship, such as a contract or a deed. This ability to use time from a previous adverse possessor is known as tacking and may allow a possessor of property to meet the statutory period without personally adversely possessing the land. An owner can avert the danger of involuntary alienation by adverse possession by periodically inspecting the property within the statutory deadlines and evicting any trespassers found. Another form of involuntary alienation is eminent domain. Eminent domain is the government's constitutional power to take private property for public use, such as for roads, fire stations, or landfills, as long as the owner receives just compensation. Be aware of this. The process of taking private property for public use through eminent domain is known as appropriation or condemnation. The process is known as condemnation. Next, we have Estoppel. Estoppel prevents a person from claiming a right or interest that is inconsistent with the person's previous statements or acts. As a basis for involuntary alienation, the doctrine of estoppel can prevent an owner from reclaiming a property that was transferred under false pretenses. For example, an owner conveys a property with a defective title. The grantor is fully aware of the defect but makes no disclosure to the grantee. The grantor later cures the defect and then claims to be the rightful owner of the property on the basis of the effort and expense of clearing the title. Estoppel disallows the grantor's claim because of the prior conveyance action. The grantee remains legal owner and benefits from the cleared title as well. All right, let's ask you some questions now based on what we just learned. Question number 1. During a person's lifetime, title to real estate may be transferred by which method? A. Descent, B. Devise, C. Escheat, or D. Involuntary alienation. Well, if it's during somebody's lifetime, the answer would have to be D. Involuntary alienation. Descent, devise, and escheat are all related to someone's estate after death. Question number 2. Of these, which is not an example of involuntary alienation? A. Adverse possession, B. Condemnation, C. Foreclosure, D. Signing a deed. The answer will be D. Signing a deed is the most common example of voluntary alienation. The other choices are examples of involuntary alienation. Question number 3. When a person dies with a will, it is considered blank. When a person dies without a will, it is called blank. Answer A. Descent, devise, B. Intestate, devise, C. Intestate, testate, D. Testate, intestate. The answer will be D. With a will is testate, without a will is intestate. Question number 4. What is the term that describes how title to land is gained by the open and notorious, hostile and adverse, exclusive and continuous use of another's land for a designated period of time as defined by laws of the state? A. Adverse possession, B. Eminent domain, C. Devise, D. Intestate. Our answer is A. This acquisition is through adverse possession. Our question number 5. When property escheats, the title A. passes to the named heirs, B. passes to the next of kin, C. reverts to the named remainderman, or D. reverts to the state. The answer is D. When somebody dies intestate and has no heirs, the property reverts to the state through the process of escheat. Note that in some states, property escheats to the county in which the property is located, not to the state. Question number 6. Eminent Domain and Escheat are two examples of A. Voluntary alienation, B. Adverse possession, C. Transfer of title by descent, or D. Involuntary alienation. The answer is D. Involuntary alienation. The right of eminent domain allows a government entity to compel the transfer of a property to that entity for a price set by court process called condemnation. This transfer of title is forced and so is involuntary. When a person dies without a will, intestate, and without heirs, the property passes to the state. The process was neither planned nor initiated by the owner before death, and is so classified as involuntary. Our last question. A property owner can avert the danger of losing title by adverse possession by A. Recording proof of ownership in county title records, B. Inspecting the property and evicting any trespassers found, C. Claiming a hostile and notorious possession, or D. Filing a claim of right with the county recorder. Our answer is B. By inspecting the property and evicting any trespassers found. Thank you for watching our video. I hope now you have a little better understanding of transfer of title and different ways to accomplish that. Please visit realestatetutorbob.com to learn about how we can meet one-on-one to discuss all the topics and concepts that you need to understand to pass your real estate licensing exam. Thank you for watching. Remember, subscribe and ring that bell. We'll inform you of our next video as it comes out. Thank you.